Hello, YouTube. I'm Vince White. I'm an employment attorney, and we answer questions from YouTube users, getting folks the answers they need from an employment attorney on this channel. And we've got a messy question today. It's from YouTube user Amber Stickles. And I'm going to read the question in a minute, but let me first say organized labor is important. Unions, union representation, the union and organized labor movement in the United States has been incredibly important and is still, I believe, the path forward for employees in this country. Half of all unions do amazing, amazing work. And I'm judging this by the metric of New York, right? New York State, New York City, where I came up as an employment attorney. So it could be different in different parts of the country, but in New York City, I would say that half of all unions are doing amazing work, fighting the good fight, making progress, creating new safety measures, new benefits, fighting for better compensation, everything. But you'll notice that I said half of them are doing that. The other half range on a spectrum from lazy to actively defrauding their members and corrupt and colluding with management, right? There's a lot of really bad unions in the world, and certainly in New York State, New York City. Now, I'm not going to start naming names because that sounds dangerous for my well-being. But that's the background. That's my take on unions. And I wanted to present that real quick before I read Amber Stickles' question into the record, and then we start kind of digging in and trying to answer. So she asks, I assume, I don't mean to assume your gender, Amber Stickles. Amber Stickles asks, "Hi Vince, thanks for another great video. You managed to pack so much information into a short amount of time. You're welcome. I hope it helps. I'm currently going through a workplace legal nightmare, and your videos have been a blessing." That's great. I'm really happy to hear that. I was wondering if you could do a video on the dynamics of the employer-union-employee relationship and duties. In short, my situation involves a union president who colluded with two administrators, neither of whom was the superintendent, to put me on a plan that was not part of my contract. It was specifically designed by the administrators and the union president, and then use that plan to target me. Several union representatives tried to help me, and when the union president found out, she banned them from helping me. I filed a charge with my state's Department of Labor Relations, excuse me, and then the union president told the superintendent, and I got fired by the superintendent the day after I filed the charge against the union. So now there's litigation with the employer and with the union both. Will any settlement agreements with one party affect my settlements with the other in any capacity? I know you try to do videos that will help the most people and that my situation is probably uncommon, so I understand if a video on this topic is not a priority. I will continue to be a huge fan of your videos no matter what. Well, thank you. That's very kind of you. Excuse my cough. So I don't think your situation's as uncommon as you think, and I say that because repeatedly in my career, I've been forced to bring a discrimination case against an employer and then also bring a discrimination case against a union. And we'll answer, I think, the core of your question, which I'll read it again. Will any settlement agreements with one party affect my settlement with the other in any capacity? Yes, to an extent. So you don't have to. You have to first off be careful when you're settling. Let's say you're settling with the employer and you want to keep the case against the union. You need to go very carefully through the releases you're signing and make sure that you're not releasing the union, right? If the union and the employer are really in bed together, it's entirely possible the union might say to the employer, hey, when you settle with Amber Stickles, get some releases in there for us. And, maybe her attorney will be asleep at the wheel, and maybe just everything will get settled and our case will be over and we don't have to pay her separately. Seeing it happen, seeing them try it, right? Now, this other thing you need to think about is the pool of damages, right? So under whatever discrimination statutes you're using will have some means of establishing the pool of damages. How much, excuse me, your economic damages are, your emotional damages, and even potentially your punitive damages. Depending on where you are in the country, what statutes you're using, there's different ways of determining this. But generally speaking, you can't recover that pool repeatedly. So, give you an example. Let's say you've done the calculation, and we'll just say $100,000 for easy math. You've done the calculation, and you feel that your combined emotional and economic damages for what your employer did to you, the discrimination your employer committed, is worth $100,000. That's what you believe the correct amount is that you could win at trial. And your employer comes to you and says, hey, we'll pay you $80,000 to settle this right now. And you say, okay. Good, great. That makes you happy. That makes you happy. I'm glad to hear it. You got yourself a deal, it sounds like. Well, then your union could later argue, when you're trying to establish damages in that case, hey, so the pool of damages for this job was about $100,000, and the employer already paid about $80,000 of that. So we don't think we should be on the hook for $100,000. We think we should be on the hook. If judge, you think we did something wrong here, we think we should be under the hook for the remaining $20,000. Now you can argue, whoa, you did other things. That's not that simple, and you didn't place me other jobs. Your failures caused additional and separate emotional damages. You retaliated against me, and that caused punitive damages that weren't part of that settlement. There's a lot of things you can argue, but you need to be aware that's now an argument that the union in a separate case might make. And yes, I do, generally speaking, encourage you to consider doing those in separate cases. It can often be more grinding to have the employer and the union have to appear different days. They can't really work together quite the same. There's some small advantages to doing it separately. If you can, if you're allowed, right? So this is relatively common, right? The classic example, Amber Stickles, is you file a discrimination case, because your union won't, generally speaking. Unions generally don't file discrimination cases for people. Also, a lot of union members have this misconception that their union is going to pay for their counsel in their workplace discrimination case. That is generally not the case. Has it happened? Yeah. Somebody's going to post down below, my union paid. Great. That does occasionally happen. It's very, very rare. Most unions will tell you, oh, yeah, good luck with that. Yeah, we're not going to pay. And you might say, but I've been paying you dues for 30 years. And they're going to say, yeah, and we love you for that, but go pound salt. It's not going to happen. That's just the reality. That is how it generally goes with unions. Not always, but generally. But the more... So let's see, you got your discrimination case against your union in this hypothetical. Oh, I misspoke. You got your discrimination case against the employer in this hypothetical. But an employer's got some pretty special deals with some higher ups in your union. Little one hand washes the other kind of situation. I take care of you, you take care of me. We run this show, and everybody makes money, and everybody's happy. That's fairly common with the lesser unions of the world. It's real easy for management and union leadership to become friendly, right? So you file your discrimination case, which your union is not involved in, but all of a sudden your union starts to do unpleasant things to you. Starts to withdraw, starts to not show up to disciplinary meetings when you need your rep there. Maybe they won't file the grievance for you. Maybe they won't do the step grievance process. There's a lot of they show up and they start arguing against you, right? Or law enforcement professional sues the department for discrimination or sexual harassment, and all of a sudden the union won't show up to argue they should keep their service piece, right? Sometimes you get gun hearings as an officer, and you have to go and say, yeah, I am of sound mind and competent and well trained to carry my my duty weapon. And the union would say, we don't take a position on this, and we're not going to be involved. That is not a good look. That gun off, whatever judge or arbitrator is overhearing that, is seeing that gun hearing, is going to say, hold on, wait, what? The union won't take your side in terms of keeping your duty weapon, which is the means by which that you ply your trade, and because it's pretty key to being an officer in many situations. Also, how you would defend yourself if some potential criminal decided to murder you. Well, that's pretty dark. This officer must be a real danger to his or herself and others. I don't know what to do. Maybe I should take the weapon, right? Like, I have seen that personally, repeatedly. Law enforcement, corrections, probation, like this is a common thing. When you step over that blue line, be aware your union will not come running. Also be aware, if you put out a call for help, your coworkers may not come running. That can be very scary. That is a very scary thing as a professional in that field, if you want to stand up against workplace discrimination or stand up against workplace sexual harassment, right? So all of this is a long-winded way of saying retaliation from a union member is more commonplace than you might think, Amber Stickles, and that's why I chose your question and thought it was really valuable for folks to hear. And yeah, sometimes you gotta sue everybody and let the courts figure it out, because that's just one means of shining a light on corruption. And hopefully you're successful, and all the little grubs and roaches, they're all little corrupt deals, need to skitter away because you won your case. Amber, if this was helpful, like, subscribe, comment down below. If it wasn't, if I failed to answer your question in some way, I will track the comments, and I will do better if you tell me how I fell short. I will try to give you more specificity or try to give a more directed answer. And I very much do hope this helps in some way. Remember, everybody works. Not everybody wins.